If you are part of a blended family, meaning your spouse is not the legal parent of your children, or you are not the legal parent of your spouse's children, how your estate will pass after you die is far from cut and dry if you don't do the proper planning. Let's suppose we have a wife and a husband who married later in life, and each brought children from prior relationships into the family. If either the wife or husband were to die without having done proper estate planning, the first problem the family would have would be determining what among the deceased spouse's property is marital or community property, and what is separate or individual property. Where the estate passes to the surviving spouse or the children of the deceased spouse depends greatly on that distinction. Married couples are free to determine which of their assets are marital and which are separate property during their lives by creating a marital property agreement. But trying to figure it out after a spouse dies is an incredible hassle and could easily lead to some severe family infighting. So, let's say the couple nips that problem in the bud by titling their assets jointly, and by having each other be the primary beneficiary on private accounts like their IRAs and life insurance. This will assure that everything will pass directly to the surviving spouse, marital or separate property characterization notwithstanding. But here's the problem there. Let's say the wife passes first, leaving everything to the husband. Now, when the husband dies, everything will go to his children, leaving the wife's children with nothing. Okay, so we'll try to fix that by having the wife co-own some assets with her husband, but beneficiary designate some accounts like her IRA or life insurance to her children. Will that work? Probably not. Here, we again have to determine what assets are marital property, separate property, or both. Yes, it can be both. If part or all of the inheritance left to the wife's children was marital property, the husband has the right to take the kids to court to get some of it back. What a mess. So is there any way to ensure family harmony after a spouse in a blended family passes away without proper estate planning? Simply, no. All blended families absolutely need to create a marital property agreement to designate their assets as marital or separate property in the manner they wish, and a fully fleshed out estate plan centered around a will or trust to avoid family infighting. With proper estate planning, you can ensure that assets are divided upon the death of the first spouse between the children and the surviving spouse without conflict. Or you can have all of those assets held in a trust share to benefit the surviving spouse during his or her lifetime if necessary, and then pass to the children after the surviving spouse's death. To create a plan to work best for your blended family, you should have a sit-down with an experienced estate planning attorney soon.